car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Welcome. You are in the right place. You are watching The Attorneys. I'm Art Franklin. We'll get to Josh Wright in just a minute, but I want to tell you about tonight's show. We're talking about wills versus trusts. But before we get into that, I want to remind you also that attorneys from Hollis Wright, they're standing by right now to take your call. They do that at the beginning of the show and they stay on throughout the show. All you have to do is dial 1-844-LAW-TALK. You don't really dial anymore. You can punch the numbers, but 1-844-LAW-TALK for a free and confidential call with one of the attorneys at Hollis Wright. Good to see you, Josh.
Good to see you too. Hope you had a great week.
Had a great week.
All right, so there is a statistic that Bobby Lott gave us, which is 65% of all people will pass away in Alabama without some level of estate planning.
That's right.
And we're going to solve and fix that today because we're going to unwrap a topic related to living trusts and wills and what's better for you, what's not better for you, what the benefits are of different things. And this is something that's going to affect all of us. And we talk a lot that our parents, as they got older, we had to worry about those types of things. For us, we've got to worry about it. But this is going to impact everybody. So first of all, Bobby, thank you for being on.
Right, thanks for having me,
Bobby's
Josh.
been on a ton, is an expert in this area. First, tell us a little bit about your practice. I know before we started the show, I was just asking what you're seeing and kind of how your practice is going, but tell us just a little bit about your practice.
Thanks. Yes, I've noticed over the past years, especially the past 10 years or so, more and more people are moving away from your standard wills over to a revocable living trust. All right, and there's many reasons for that, which of course we'll talk about. But one of the primary reasons is that you don't have to go to probate when somebody passes away. Everything's done ahead of time, so it takes a big chunk of the process away.
Talk just generally about what a living trust is. And compare it just a little bit to, and I know we'll unwrap this throughout the show, but just generally what a will is, kind of the two and how they're a little bit different from one another.
Okay, sure. Yeah, a will, which most people know, maybe you don't, is a document that you draft up or you have an attorney typically draft for you that gives instructions to your family, your friends, it can be charities involved, et cetera, about what you want to have happen with your property, your stuff, whenever you pass away, okay? Now, once it's done, nothing really happens with it. It doesn't get filed anywhere. You don't have to show it to anybody. You can, but you don't have to. Nothing happens with it until you die. Now, once you die, whoever you left in charge of your estate, typically a family member, but not always, to do anything with your property, they have to go to court and get a judge's blessing to make sure everything's okay in your will. Once they do that, then the person that you designate in your will takes charge of your estate. Okay, that's a will. Okay. Now, a living trust, and let me specify what a living trust is. Sometimes people are not familiar with that. Another term for it is a revocable trust or an inter vivos trust, which is just a Latin way of saying between the living. It's a trust that you create while you're alive, all right? The main difference is the trust takes effect the day you sign it. Okay, it doesn't have to go to court. When you pass away, whoever you designate to take control of your affairs, the next day after you've had your services, they take over your affairs. That's a very short definition between the two. Does
the trust document itself in a living trust have to be approved by the court at any point?
Never. Unless, and I've never had this happen, you put something in there that's, say, illegal or against public policy, something like that, which that's 1,000,000 to 1 somebody would do that. But other than that, it doesn't, no.
This seems like an easy way to work around some of the complicated natures of what people generally may go through with a will.
I'm also wondering, Josh, and who has access to that living trust?
That's a great question. Another thing that I didn't mention about a will, once you file it with the court system, it's public record. Anybody can go down to the courthouse and ask to see, if you find out, let's say a famous person has probated their will recently, you can go down there and request a copy, and they have to give it to you. That's state law. Okay? Well, the trust is completely private. Unless you tell somebody what's in there or show them a copy, it's completely confidential.
So we get questions sometimes which relate to trust, and some of the questions are things like, okay, I understand what a trust generally does, but give me an example of why someone would use a trust. What would they put in the trust to help their family member to get something to their kids? Can you give us an example of just kind of what you see with these living trusts and how they transfer after someone's passing to a trustee to be able to manage that trust?
Sure. A perfect example, and probably the most common example, is your home. Okay? If you own a home, the deed will have somebody's name on there. With a married couple, most commonly it will be the husband and wife. Jim and Mary Jones is a title that way. Okay? Now, when you pass away, when the last spouse passes away, let me rephrase that, whoever you left in charge of your estate, if you want them to have that house, they have to go to court and get that deed changed. Okay? Now, with the trust, what you will do is you will go ahead and change the title of that house to the Revocable Living Trust of John and Mary Jones, for example. All right? So now, whenever you pass away, if you designated one of your kids to take your house, they take it the next day. There's nothing legal has to be done because they are designated as it's called a successor trustee. They automatically take it.
Does the person have to still transfer a deed, or is the deed part of the trust?
The deed's already part of the trust.
So that's what solves that issue.
That's one of the main things you do is put, kind of a good rule of thumb is you put titled property in there. If you have a primary home, you may have a beach condo, things like that. Anything that has a deed or a title, you put in there. Now, you don't put everything in a trust.
Right.
Okay, there's certain things, that if you want to, we can mention those, but things like, okay.
Yeah, let's do it.
Retirement funds.
Art was about to ask that question. You could tell. He was like, yes, I want to see
I'm
this.
really wondering,
what am I not going to put in there?
Yeah, I'm wondering what value do you put on whether it's a will or a trust? How do you determine which one that you actually set up legally?
Well, certain things you don't want to put into a trust because it can be a taxable event. For example, IRA, 401k, those two, unless you're above a certain age threshold, if you put those into a trust, the IRS will see that as like you're cashing it out, and they may tax you on that. Okay. So what you do, you solve that problem. You've already got a beneficiary designated on your IRA or your 401k, so it bypasses your estate anyway. Does that make sense?
Yeah.
So it's not part of your estate, just like life insurance. That's not part of your estate either.
So do you have both, a will and a living trust?
Well, I have just a trust, but it has a pour-over will within the trust. And I can explain what that is if you like.
Yeah, let's do this. We're going to go to break because I know we got to go to break. But this is good stuff. And by the way, this is why we bring guys like Bobby Lott on, because if you need estate planning, you need to go. You don't come to the Hollis Wright law firm, right? You come to Bobby Lott's firm, and if you forget Bobby's name, you contact us and we're going to get you to Bobby because he knows how to do this stuff, and he will sit down with you and talk with you and lead, guide, and direct you through this and answer these questions. And so it's the reason why we bring guests like Mr. Lott on to be able to talk about
That's
it.
right. And
so we'll unwrap that when we come back.
Yeah, and they also give us good information like Josh gave you at the top of this discussion. And throughout the show, you'll see that information scrolling on the screen. We like to keep you informed, not just in the discussion, in the conversation, but also in the information that we provide throughout the show. So stay right there. You're watching The Attorneys. We're going to step aside for just a few, but we'll be back with more as we're talking about living trusts and wills. Stay with us.
Here's some good information from our firm to you. Hollis Wright recently launched the Law Talk podcast. With podcasts becoming so popular, this will be a simple way to provide our loyal viewers with more opportunities to access information about important legal topics and to learn more about our firm and how we can help you if the need ever arises. There are many ways to access the Law Talk podcast. You can simply scan the QR code on your screen. Also, episodes are always available on the Hollis Wright YouTube channel, as well as on Spotify, Apple Podcasts, or wherever you consume your podcasts. Just search up Hollis Wright in the Law Talk podcast. Don't wait, take advantage and listen today. Thanks for watching The Attorneys, and we know you'll enjoy the Law Talk podcast.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas such as bankruptcy, criminal law, civil law such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Addiction kills hope.
But at Bradford, it all changes here.
Experience the difference
that proven treatment can make.
Find recovery. Find community.
at Bradford.
Living trust versus wills. That's what we're discussing on The Attorneys. We'd like to welcome you back to the show and also remind you that attorneys at Hollis Wright, they're standing by at 1-844-LAW-TALK. Give you a free and confidential call, so go ahead and make that call right now as we're talking about this really fascinating discussion, and it means so much, and it's so important to us for our bottom line here and our bottom line for our children and grandchildren.
Yeah, and I'm actually getting educated myself because this has such great qualities to it relative to the traditional will that my wife and I have. And so I'm learning here, and that's part of these questions are related to me personally. But, you know, ultimately, you know, we left out to break and we were talking about whether you would even want a will if you're going to have a living trust that may transfer property at your passing. Do you need a will? And you mentioned it was called a pour-over will that you could have inside your living trust. Explain that a little bit.
Okay. Yes, typically a trust will have within the document itself, it's called a pour-over. A pour-over, it pours over into the trust. And all that is, and it's most of the time it's not used at all. It's only kind of a fail-safe mechanism. If you forget after you set your trust up to move some property into the trust while you're alive, whoever your personal representative is that handles your affairs after you pass, they will have to open up a small estate just for that property because it'll still be titled in your name, not the trust name. A perfect example would be, let's say that during your lifetime, after you set the trust up, a relative leaves you a piece of property somewhere out of state. You don't move there, you don't build on it, you sort of forget about it. And then you never move that property into the trust. Once you die, then your family member will need to open up an estate just to deal with that piece of property. But see, if you stay on top of it, and most people do, you will have moved that into your trust already. So it's not even an issue. So it just sort of sits there, but it's there if you need it. So
talk a little bit about, and I know this is a complicated topic, but everyone understands that paying taxes is something they need to be concerned about and make sure that it's being done correctly and they're being wise in the decision making to use the tax code to their advantage. And so there's something called a basis in certain things, like a house, for example. Can you explain how a living trust can be better to do than some other product because it gives a basis step up, which means the child who gets a piece of property isn't going to pay capital gains at the time of passing, where it would benefit? Does that make sense?
It does.
Okay.
And I'll try to make everybody's eyes glaze over with this. I know it's not a very interesting topic, but it's important. That's correct. All right. All basis is what somebody paid for the property. Okay. Perfect example is, let's say your parents bought a house when you were a kid for $100,000, and they go to sell it now. It's worth $500,000. Okay. Their basis is $100,000. All right. So if they sell that just outright, that's a $400,000 capital gain that they pay taxes on. All right. Now, with a trust, okay, and a will for that matter, they both get treated equally by the IRS. When you pass and you leave your property to a child, for example, all right, they take the house at the market value the day you pass away. Let's use that same house. Let's say you put that house in a trust. When your parents pass and it's worth $500,000, you leave it to your kids, they take it at a basis of $500,000. So they
no
pay
tax owed.
Right, they don't pay a gain on that. Now, whatever gain they receive after they have the house for 10 years, they pay tax on that part when they sell it.
Oh, for sure.
Right, but not what you don't pay a penalty for your parents' purchase, 20 years ago.
So what you're saying though is you would not want to allocate a house to your kids prior to your passing if it was going to appreciate, because you would rather have your kids get the house at the time of your passing to get the benefit of the basis step up.
Exactly.
Okay.
Because if you do it while they're still alive, and it happens all the time, and a parent will deed a house to their child, and then the parent will continue to live there. They call it a life estate.
Yeah.
Very common. That's fine, but two things happen. All right, you've got to have the parents and the child permission to sell the house now, because they both have a legal right to it. And the child now, when it gets sold, they're going to pay a gain on the whole time it's been deeded to them. And so you get the same effect by putting the house into a trust. Yeah. Because you're still in control as long as you're alive.
So in essence, what has happened there, just with this simple example, is you've created a taxable event at someone's passing that is unnecessary if you go to the right person to work through these issues, where you can save and not pay any tax on that home until it appreciates while you own it. Or if you sell it at the time of passing, you may have no capital gains to worry about. So it's just a great example.
If you did it the right way, you still get the same result.
Yeah.
You just wouldn't pay the tax on it.
Yeah.
We are all learning so much as we listen in. Bobby, I'm thinking some people at home may be thinking the same thing. Aren't living trusts just for rich people?
I used to think the same thing, but they're truly not. I mean, when I was a kid, maybe all the same way. You'd hear about trust. You'd hear about people like, I'm kind of aging myself, but the Rockefellers, the Fords, people like that. Now it's Bill Gates and Jeff Bezos, people like that. They all have trust. Right. Well, they're ultra rich. Yeah. And most people are not. But see, the great thing about it is, if you own any sort of property, if you just own a house or a condo, you need a trust. Yeah. In my recommendation, or at least a will. A will's better than nothing. Yeah. It's just that it doesn't have the set of benefits that come with it like a trust does.
Is it expensive to set up?
It's a little more expensive up front, but the value you get from spending a little bit more money up front is so much greater than it is having to go through the probate process, because they can drag on for years, literally for years.
And not just that, the probate process, oftentimes before you can do many distributions, you've got to wait 6 months to have the probate open.
That's by law, a minimum 6 months.
That's right, unless, of course, if there was a will that defines something different, don't necessarily have to follow the same probate process. There are some things you can put in a will to help yourself.
Right, and also don't forget that a will can be contested. Yeah. Occasionally there'll be someone that gets cut out of a will and they find out and they'll sue. And that can cause delays for many years and cause a lot of money, attorney's fees, expenses, that sort of thing. You avoid all that with a trust.
We're going to break, I know. Let's do this when we come back. I want to talk about and have Bobby talk just generally about how he handles a client that comes in and says, look, I don't know how to do this, but I have property, or I have money that I've earned, or I have a profit sharing plan. I want to make sure my kids have a future, and I want to build a legacy for them. What do I do? And I want to talk about how he handles that and manages that.
That's good. You're probably at home wondering the very same thing that Josh just talked about. What do I do? As we're talking about living wills and trusts, you've come to the right place. This is the attorneys, where we give you good information like that. Also, you can get information from an attorney standing by on the phone right now at 1-844-LAW-TALK for a free confidential call. You got just a little while longer in the show to make that call. Stick around. We'll be back right here on The Attorneys.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
If this place could talk, it wouldn't. It would sing and celebrate all of our stories of addiction recovery, victory, and community. This is Bradford Health Services. It all changes here.
Welcome back. You're watching The Attorneys, and as we went to break, we left you with the question, what to do. It's a question that Josh posed, and Bobby's going to answer.
Yeah, and so here's the question. You gave me a statistic. 65% of people die without estate planning. That's horrific.
Sad.
That should not happen. People think, I'm assuming, that doing a will, doing a living trust is too expensive for them. And I know you're going to be able to tell us it's not, and it can be done super efficiently. But what do you do when someone comes in your office and says, look, I need help. Here's what I have in my life. I want to build a legacy for my children. How do I get started? How do you handle that?
Great question. First of all, it's not one size fits all. Everybody has a slightly different situation in their life. So I take the time to find out, just like you said, what is your situation? What sort of property do you own? What are your goals? Are you trying to just provide for your kids, so when you pass that they'll be taken care of? Do you have small children? Do you have minors? All right, what about their education? What's your goals for them? Do you want to have them receive everything they're going to get in one lump sum? Or do you want to spread it out? All that can be done very easily. And once we determine the best vehicle for them, we can do it one of several ways. More and more people are getting to where they they're being more tech savvy, I guess you'd call it. They just, will ask me to prepare the documents, and we'll go over them, make sure everything is just right, all the T's are crossed, and I just send them to them, and they take care of getting it notarized and signed, and email me copies, which I'm fine with that. But there's also people that want a much more personal touch, which is great too. We'll sit at the kitchen table or in my office, wherever, and go over everything in detail, and I'll take care of all the paperwork, and then once they're happy with it, we'll talk on the phone afterwards a couple times a week. Said, I was thinking about this, and what if this would come to pass down the road? We didn't talk about that. I'd be happy to go over all that with them.
Yeah, I like this here, and I want you to tell me what it means. As of 2025, unless your estate is worth more than $27.98 million, you owe no estate taxes when you die.
That's correct. And that's for a couple. Now, for an individual, it's half that, which is at $14 million. That is where the estate taxes stand right now. Now, that can change.
Yep.
That may sunset in a couple of years. That's a congressional issue. That's a political football, so to speak. Some people think that's way too high. Others think no, there should be zero estate taxes. And of course, estate taxes are what you pay when you pass away, the value of your estate. All right. Now, so unless you are ultra rich and have property and assets worth that much or more than that, you don't pay an estate tax.
You know, and what Bobby can also tell us is, you know, making sure that you structure things correctly as what I call a beneficiary distribution that flows outside of an estate, like a 401k plan, like life insurance. Those things can be beneficiary distributions. You can do the same thing with living wills with a house. And so those are ways to avoid anyone paying tax on those things. But there are also changed circumstances. People have things that happen in their life. They get divorced, they acquire new property, they lose property, they file bankruptcy, things that happen that are changed circumstances. Keeping in touch with someone like you is important.
Sure, oh yeah. And you're right, people's lives change all the time.
Yeah.
And the good thing about having a trust, and a will for that matter, but they're so easy to change. With the living trust, you'll have a document that's called a Schedule A, which is basically an inventory list of what we put into their trust. As you buy and sell property, that's just a simple document that you amend and you keep yourself in a safe place, gun safe, safe deposit box, something like that. And just lists all the things that are in your trust and things that have been taken out. And see, none of that happens has to be recorded anywhere outside of the transaction itself.
So you're able
the courts never get involved.
You're able to keep it completely private.
Completely private.
And internal to your family.
Yep.
That's probably part of the reason why some of those names that you mentioned earlier, the Hershey's and the Rockefellers, had trusts and used trusts to keep their business private. It's another way to do it. You have provided a tremendous service today. My hope is that there are people watching now or that will watch this on demand and will say to themselves, I'm not going to be part of the 65% statistic of people that have no estate planning. I'm going to do some estate planning because of guys like you.
Well, you're so true, you're so right. And if people will just take that first step and call somebody, any attorney would be glad to talk to them about this. Should be no obligation at all.
Great job. Great job. Thanks for being on.
But a great one they can talk to is Bobby Lott.
Yep, of course, absolutely.
All right, Bobby, thank you so much. Josh, again, thank you as always. And thank you for watching. We certainly appreciate that and hope to see you back here for another episode of The Attorneys next place, same time next week. See you.
Thanks for watching The Attorneys, sponsored by Hollis Wright.